Oh, yes. I was looking at this 9C or RCW 9A72.010. Yes. Now, there's some definitions that I know are very important to the actual understanding of the laws of the state of Washington. Yes. Now, the following definitions are applicable in this chapter unless the context otherwise requires. One, a materially false statement means any false statement, oral or written, regardless of its admissibility under the rules of evidence, which could have affected the course or outcome of the proceeding. Whether a false statement is material shall be determined by the court as a matter of law. Two, oath includes an affirmation and every other mode authorized by law of attesting to the truth of that which is stated in this chapter. Written statements shall be treated as if made under oath. That would be every declaration made under oath. Yes. Every time that you appeared in court and you said, well, he's crazy. Oh. Now, the statement, let's see, that's bullet point A. Yes. The statement was made on or pursuant to instructions on an official form bearing notice, authorized by law to the effect that false statements made therein are punishable. Ouch, false statements. Now, these declarations, yes. And then you made these court orders, and I think there's an oath required when issuing a court order. Yes. That you said that I received actual notice when I didn't? Poach. Is it that the court commissioner is under oath while serving in the capacity of court commissioner? Yes. Now, bullet point B. The statement recites that it was made under oath under the penalty of perjury? Yes. Was the petitioner in court on July 31st of 2015 and is it legal to enforce a court order where the petitioner did not appear in court? Pooch. Did the petitioner actually motion the court to reissue the court order on June 1st of 2015? Pooch. Or on June 22nd of 2015? Yes. The statement recites that it was made under oath. The declarant was aware of such recitation at the time he or she made the statement, intended that the statement should be represented as a sworn statement, and the statement was in fact so represented by its delivery or utterance with the signed jurat of an officer authorized to administer oaths appended thereto. Or it is a statement, bullet point C, declaration, verification, or certificate made within or outside the state of Washington, which is certified or declared to be true under the penalty of perjury as provided in RCW 9A.72.085. Now, there's number 3. An oath is required or authorized by law. Under oath, Sheriff. The individual that served me in the Sequim Public Library, is he a sheriff or is he not a sheriff? Now, was it a wrongful execution of a court order? Was the individual authorized by law to actually serve me in the Sequim Public Library? See, without the authorization of law to serve an individual a court order, it could be considered that it was not served as required or authorized by law. Now, I know a lot of individuals, when they go to serving court orders, the court actually orders that somebody over the age of 18 that is not a party to the actual case itself, yes, is authorized by law to serve an individual. But when the actual court order says that the sheriff, the Clallam County Sheriff's Department, on or before the official proceedings, means a proceeding hearing before any legislative, yes, judicial, administrative, or other government agency or official authorized to hear evidence under oath, including any referee, hearing examiner, commissioner, notary, or any other person taking testimony or deposition. Now they have what's known as the jurors, means any person who is a member of any jury, including a grand jury, a grand jury indictment, to spend the rest of your lives in military prison for refusing to enforce the law, being unable to enforce the law, failing to enforce the law. It's going to be nice when the military finally decides to step in and make sure that all state and federal law enforcement, now impaneled by any court of this state or by any public service authorized by law to impanel a jury. The term juror also includes any person who has been drawn or summoned to attend as a prospective juror. Yes, you could be a juror in the event that somebody died from the time that they were. You're like a backup juror. Yes, yes. The testimony includes oral written statements. Yes. Documents or any other material that may be offered by a witness in an official proceeding. Now, this whole purpose of the act is to respond to State versus Thomas. Yes, without changes. And then exactly what kind? Legislation perjury is amended. The act is necessary for the immediate preservation of the public peace, health, or safety, or support of the state government and its existing public institutions, and to take effect immediately, May 7th of 2001. Perjury in the first degree. Class B felony. Now, a person is guilty of perjury in the first degree now that we understand the definitions. Yes. If in any official proceeding, meaning any court hearing, yes, any time that you were before elected or appointed oath of office, he or she makes a materially false statement which he or she knows to be a false under oath required and authorized by law. You remember those oaths of office? Yes. And the individuals elected and appointed to office? Yes. Now, can a forgery of the ex-officio superior court clerk be known as perjury in the first degree because of the individual that signed her signature and used the state court stamp? Pooch! Could it be perjury in the first degree to certify something as the actual protection order served on the respondent in the Sequim Public Library without the state court seal or the forgery of the individual that committed perjury? Now, it's first degree in any official proceeding. That's right. Knowledge of the materiality of the statement is not an element of this crime. And the actor's mistaken belief that his or her statement was not material is not a defense to a prosecution under this section. Class B felony. Now, if you think about these different felonies, do you want to get a Class A felony, a Class B felony, or a Class C felony?